And we're back. Chuck Augustine, Tom Gibson with Nye County. And Chuck, you had some things you wanted to address before we get to the main topics?
One of the things I want to address, because it drives me crazy when I hear people say facts matter and people don't know the facts, here are the facts. And there's this other word called perception. And anyone that's been in intelligence like I was, or in life, period, understands, I think, that there are very few hard facts that everyone would agree upon. That's what happened, or that's what's going to happen, or that's what is happening.
Or it's relative, like facts. Water is wet. Freeze it. Yeah. Freeze it. Now tell me how wet it is. I mean, so it depends on what state it's in. So. And I'm not talking about which of the 50 states. I'm talking about it's a physical state.
Yeah, and what people tend to do is they look, a lot of people look at a bias, for example, the news, either liberal or conservative, and they don't look at the other side and they say, here are the facts because this is what the one side told me. And then the other guy will say the opposite because the other side told him the opposite. But even if you look at both and try to get a balanced view of what's going on in the world, you've got to understand that you're reading someone's perception of what's going on. And you're perceiving it and translating their report, their article or whatever, into your version of what's going on. In other words, you're coming up with a perception based on a perception, and the fact may or may not be true that started all this.
Great.
And I know in court, how many cases revolve around eyewitness reports and statements from witnesses.
Right.
But, you know, those are not facts. That's why hopefully more and more people will demand jury trials, because just because someone says, you know, you threatened me with a gun and pointed it at me, doesn't make it a fact.
Here's the problem, though. When a person is arrested and they're being prosecuted and they're going to trial and they're looking at, like, the worst case scenario, like, say, you know, 10 years in prison, and the DA shows up and smiles and says, I'm going to give you a misdemeanor, like he's doing you a favor, okay? And you're like, well, that's all well and good, but my client is innocent. And then, but the problem is you know, but you tell the client, yeah, I have to, as a lawyer, whenever I'm given an offer, I have to convey it. And then you explain the situation to the client, and they're like, well, if I, you know, I got a 70% chance at winning this, but I have a 30% chance at losing it. And that 30% will put me in prison, make me a convicted felon, and it will ruin my life. And what am I going to do? And they're offering me a misdemeanor and a small fine, and people will do the simpler thing. It also happens all the time, too, when in the federal system, I saw it all the time, because they have, if you have a certain amount of points against you, you're called, and it's not a what do you call it? It's not the 3 strikes rule. That's a whole different thing. But you're, Jesus.
Perpetual prison or criminal or something?
Yeah, habitual criminal. Yeah. And so, and no. Sorry, it's a career offender.
Oh,
habitual criminal is in state court. So it's called a career offender. And then so if you're a career offender, they have a whole new guideline that they go after, and they'll max you out on it. So. And these people, they get like misdemeanor. But a misdemeanor is 1 point, and a felony is 2 points. Gross misdemeanor, 1 point. So we get a guy that has, through his life, gets, you know, maybe 10 misdemeanors. All of a sudden, he's a habitual offender, or actually a career offender. That's not right, but that's how it works. And so if they'd only said not guilty on the little ones, they wouldn't have had the big one to begin with. So I always tell people, by the time you hit the big leagues and you've got the big felonies, it's almost too late, because all the other stuff in your criminal past, misto, gross, misto, felony, reduced, all those add up in the federal system, and you're totally screwed. And they're also, your record is screwed too in the state system as well, but not as bad.
Right. And another aspect of that is if, say they're charged with a felony and they go all the way to trial and they don't get a public defender, they're going to pay a lot of money for the lawyer to go all the way to the jury. And it's a significant amount.
A private lawyer to do a jury trial, I mean, minimum of $15,000, and that's if you're lucky. Most attorneys want $25,000 to $40,000, and I know an attorney, you know, back east. He's very good, but he won't even meet with a client unless they have $50,000, and that's to meet with them. Now, mind you, he meets with them and he will take the case, but 50 grand is what he costs.
So in essence, you got to be a criminal to afford to go to trial.
No.
Really, and that that is the truth in a lot of respects, and that's why the big druggies and all the rest, they don't even pursue them because they can afford the best defense.
And then are you aware that the public defender's office is under scrutiny now? The county's being sued by the ACLU. Oh, did you already have that?
Yeah, well, I brought it with me.
Okay, yeah, and I mean, I don't know all the gory details, but it's basically caseloads are too large. There's not enough, they're not doing enough trials, and it's just to the point where there's no. The defendants do not feel that they're getting a fair shake, and I know every one of those public defenders, and they're all very capable lawyers. But I will also say, having been there, the caseload is too large, and you can't effectively do your job when you have a huge caseload, but not just a caseload, because you can't even work on the stinking cases because all of a sudden the judge is calling you, hey, we're having in custodies. Well, isn't that nice? You know? So you got to drop what you're doing, run to the courthouse because the judge has decided that they're going to see these people who were just arrested the night before at the last minute. And now, in my earlier contract, when it was when it was Gibson and Keene, where it was the public defenders, we were able to. It wasn't in our contract that we had to go to the in-custody arraignments. So when Jason, Ernest, and Harry Keene, they were happy. They wanted that contract so bad that they would run off there and try to do everything they could to appease the judges. I remember I got a call once from the former Judge Kent, and the
my buddy.
Yeah, and the clerk said, Judge Kent having in custody. I said, congratulations. And she goes, well, he needs an attorney here, and I said, well, I'm too busy. Click, all right, because why should I didn't have to, and I wasn't going to, and I was being a little smart alecky, but at the same time, you got to put your foot down because those people walk all over if you allow them.
Real quick, correct me if I'm wrong, we got 5 public defenders, and they make 150 grand a year each.
Base. I believe that's the base.
Right. Okay, Ray, we got you back on the line. I think it's Ray.
Yeah, Ray the Flagman again. I've been a court observer for the last 15 years. I sit in on a daily basis. I encourage other people to sit in and see what's actually going on in these courts. One thing that really offends me, Mr. Gibson, is when I hear the judge and or the prosecutor saying how many arrests some of these people have, and it's usually at sentencing. And they go through the whole tirade of stuff where people have not even been found guilty, but they say, well, they keep running these charges. Maybe they negotiated a major charge down to a lesser charge. Is that proper for them to do that?
They can, and they do, and so does everybody else in the nation.
Yeah, but I mean, doesn't it sound if you're arrested and there's no conviction? Well,
I mean, you got to look at the other side of it, Ray. I understand what you're saying, because if there's no conviction, how can you say that person did anything wrong? But, the expression, where there's smoke, there's fire, and if a guy's got 20 arrests and no convictions, nobody gets arrested over and over and over unless there's something there. Now, mind you, if the guy's just like a petty thief or whatever, or not even a petty thief, but like somebody like a serial jaywalker, yeah, nobody's going to care. But even if he's in front of a judge and they say, oh, this guy's got 30 jaywalking arrests. So, I mean, nobody would care about that. But so when he says he's got 30 arrests or 20 arrests, whatever his arrest record is, you got to look at those arrests and see what they were for. If it was like child molestation and every time he was going to go to trial, the kid the kids like backed off for fear because maybe it's like the Clinton crime family was involved somehow, and threaten the people like they've done to Clinton's accusers, and you lose your witnesses. Well, those arrests are relevant, right?
Well, also the stay out of trouble clause that they put in justice court, where if you just get arrested, there's no conviction, all of a sudden they impose a suspended sentence. Sometimes it's 6 months just because you got arrested and there was probable cause. That is not right. They got to do away with this, Tom, because
I agree with that.
People going to the slammer because they were arrested. Probable cause was found. And so they said they have to impose a suspended sentence. And I want to pose one more question. It'll be a quick one because you guys are going to break. Is it in a criminal jury trial, is it important for all 12 people to say guilty, or if any partial amount can say guilty or not innocent or innocent? How would that work? Does it have to be unanimous in a criminal jury trial?
Ray,
Tom Gibson, can you answer that question?
A criminal jury has to be unanimous. Civil juries,
now, Chuck
civil juries don't have
out
to be.
on that one, and I'll let you go, and we'll talk in a little while. All right? Tell him, Chuck. You know what I mean, right?
I know what you mean.
Okay.
What Ray found, and I haven't looked on the internet yet, but he said that in 2 states you can have 10 not guilty and 2 guilty, and it's not guilty. Yeah, it's an acquittal. Okay. Or the other way around.
In Louisiana, Chuck.
Louisiana and Oregon.
In Louisiana, a guy was convicted of murder with only 11 voting for conviction. 1 voted against it. But in Louisiana, it's 10, and in Oregon, it's 10. And I don't think that's right. They're trying to change it, but this is, I even confronted Judge Jasperson. He had no knowledge of this either. So you can Google it, but Louis DeCanio already has, and I believe that's the case. So I'm going to open the lineup again. I hope CJ puts the number on the screen, because I'm probably the only one who has memorized this number. So you guys have a good show. Talk to you later.
727-8750.
Yeah. Do we have it on the screen?
Yeah, there you go.
All right, we got it on the screen.
Okay, where's Amy? I haven't heard from Amy tonight.
Yeah, well, maybe because it's not on the screen. By the way, congratulations to Amy. She passed, or qualified as a CASA amongst, I think there was 8 new CASAs that went through the training and that.
She's a house?
No, court-appointed special advocate,
correct.
Is it?
Yep.
Okay.
Yep.
And they represent children, basically.
Well, no, and it's a really good program, because normally, see, in family law cases, you've got dad and you got mom, and or mama is the mother and the father if they're not married, and they're viciously going after each other, and the judge is trying to decide who's going to be the primary custodian. Well, there's nobody representing the interests of the children, because I'd be representing the mother, Carl Jordan would be representing the father, and we'd be mutual annihilation. But then the judge is like, wow, this guy did a great job, this guy did a great job, now who am I going to give the kids to? So it's really helpful, because it gets it's a middle person that can kind of take some of the pressure off the judge in making that final decision. I saw.
Oh, okay.
I can see him, unlike before.
We're doing hand signals, by the way. We don't have the monitors working tonight. There's always something. It's always an experience doing a live show. So anyway, we're going to go to break right now, and we'll see you in segment 3 shortly.